All right. Hello, everyone, and welcome to our webinar, Water Damage Issues. My name is Miranda Ward, one of your client relation directors here with Davis-Stirling. We are thrilled to see so many of you today. We have a lot of information to cover, so we're going to get started. Before we begin, this meeting is being recorded. If you require closed captioning, please request it at the bottom of your screen. This video will be available on our YouTube channel after the webinar is processed. We will be taking questions via the Q&A function to be discussed at the end of the program. If we do not get to your question, check the newsletter. We are about to launch a poll. Please make sure to answer so we have an idea who is here today. Wonderful, thank you. Now on to the presentation. Please welcome founder.
Wait a minute, though, there's still a lot of stuff coming in. So let's see. Yeah, I see we've got a lot of board members on, which is good. Homeowners, managers, and vendor/professionals. Yeah, we've got, how many are answering? So we've got over 1,000 in attendance. That's good. It's a good turnout. All right, let's go ahead then, Miranda.
Wonderful. Please welcome founder and co-managing partner, Adrian Adams, and co-managing partner, Laurie Poole.
Okay, let's go ahead and go to the next slide. And here we go. Water, water is essential for life. And in fact, when they're doing space exploration, they're looking to find water because without it, you can't live. And humans are composed of, a significant, let me move the poll here, 60% water, which is essential for our bodies to survive. But as managers especially know, water is also the enemy. And we deal with water coming from tubs, toilets, sinks, inside the walls, from drains, water lines, balconies, the roofs, windows, planter boxes. We're doing everything we can to keep the water out or keep it contained in some way. Because when it gets out, water is deemed a universal solvent and it causes a lot of damage. So we have another question for everyone, and that's how many have experienced or dealt with water leaks or floods? So let's go ahead and run the poll.
Or I do think maybe a better question is how many have it?
Yeah, because it's pretty much a universal problem.
Yeah.
And that is that you've got water intrusion and then you've got to deal with the after effects of it. So if you can see from the poll, just about everybody has. We only have 4% who have not experienced water intrusion problems. So those 4% of you that said no, I can tell you that you will at some point. So unfortunately, it's just an issue that everybody experiences. Okay, so let's go move on to the next.
Wow, there are actually some no people. Wow. I want to meet you.
Okay, so let's see, did we miss a slide? So we have, yeah, just that one. Okay, so this is one of my clients that experienced water. They gave a call in that water was pouring out of their ceiling. The staff responded and ran up to her unit, saw the water, ran up the unit above, water was coming through their ceiling, went up to the unit above there, water was coming through the ceiling, and finally got up to the unit where there was a big tub overflow. They knocked on the door, the woman answered, and what happened, she turned on her tub and her phone rang. And she was still on the phone when she answered the door. She had no idea that her tub had overflowed. So this, is a unit-to-unit problem caused by an owner. And I see, do we still have the question one up? Is it still on the screen or do we need to take that down?
No,
Okay.
it's not on the screen. We're good.
Okay, good. All right, so then the first question is, when you've got a unit-to-unit problem like this caused by an owner, who pays for the damage? And we're going to run another poll. So who do you think pays? The owner who caused the damage, the owner who suffered the damage, the association, or all of the above. And I see the results are coming in. Okay, so it looks like 62% believe the owner who caused the damage is responsible for the damage, for paying for it. Others, the owner who suffered the damage, we have 2% saying the association, and we have a percentage that is saying, was it 32%? All of the above. So Laurie, what do you think?
Well, like any good lawyer answer, our favorite answer as lawyers is, well, it depends. So, and it really
Yeah.
does depend on the situation. And when we talk about paying for damage, I think it's really important at the outset of what we're talking about here today to understand there's a few things involved. One is the actual item that led to the water intrusion. In this case, it was the bathtub that overflowed. So you've got the item that might be damaged that led to the water intrusion, the pipe that burst, the roof that leaked, maybe the window that leaked. And when we look at who pays for that, if that item needs to be fixed, that pipe that burst, we're going to look at the maintenance, repair, replacement obligations under the CC&Rs. We'll talk
Right.
about that later.
Which
But
we'll
what
cover
we're
in a
really
minute.
addressing here today, and what this slide is showing, it's the resultant damage, that the damage that results from the water that's flowing. So in this
Right.
circumstance, the water is flowing from the bathtub, and it may be situations where the damage is paid for by an insurance company. May not be paid by an owner. It may be paid by an insurance company. It may be an owner's insurance company. It may be the association's insurance
Yes.
company. So that's all
Well,
the things that we're going to talk about today.
Yeah. Well, let me answer the question. And all of those who said all of the above, you're more right than wrong.
Yeah.
More often than not, when we are dealing with these issues, everybody is paying in one form or another through their insurance, or sometimes not if they don't have insurance.
Or
But-
if insurance doesn't cover the situation,
Right.
which we'll talk about as well.
So we'll go through that now so you can start seeing what we're dealing with. And then the next question, which is also important, is who repairs the damage? So this overflowing tub, and so the answer, you've got four choices here. The owner who caused the damage has to repair it. The owner who suffered the damage, do they pay for it? Does the association, not pay, but repair, or all the above, repair the damage? Okay, so we have more people saying all of the above, and the when it comes to the common areas, it's going to be the association. And for the improvements to the units, it should be the unit owners paying for those, but sometimes it's the association.
Well, we're
Yes,
not
ma'am.
talking about paying. We're talking about actually doing the repairs.
Yeah, we're doing the repairs.
Yeah. So we're talking
Uh,
about actually who's repairing, not where the
who's
money
re-
came from, but who's actually doing the
But who's
repairs.
making the repairs?
Yeah.
And it more often than not, it's going to be the association repairing a lot of the damage. Whether it's going to be improvements to the units, or it's going to be for sure the common area. Without question, they're going to be dealing with that. Okay, so let's end the poll and go to the next one. And here's the reason why. So Laurie?
Yeah. So when we talk about actually doing the repairs, performing the repairs, we're going to depend on the responsibility for repairing or replacement, those repair and replacement obligations. We're beyond maintenance. We're not talking about maintaining here. We're talking about repairing or replacing. So how do we determine that? Well, we look to the Civil Code Section 4775, which sets forth the responsibilities for the common area, the separate interests, and the exclusive use common area. And for the association is responsible for repairing and replacing the common area unless the CC&Rs provide otherwise. So we also have to look to the CC&Rs. So the damage here that's shown, which is on what looks like drywall, the ceiling and the walls, in a condominium, this repair or replacement of this drywall could be the association. because it could be common area. Remember, the boundary of the unit might be the interior finished surface. So beyond that, the drywall that's damaged here could be the association's responsibility because it's to repair, because it's common area or replace.
Okay. So what if the board is slow to fix the leaks and repair the damage? This happens sometimes too often. And what happens is that the owner that suffered the damage starts getting angry. And if the board continues to sit on it or say it's not their responsibility because it's an owner to owner damage issue, which happens a lot, because boards will say, we didn't cause the damage. That was the owner with the overflowing tub. That was her, she caused it, she's responsible, she has to fix things. And so the board steps to the sidelines. And if that happens, the owner gets angry and they go looking for a lawyer. And they will find one who will sue the association. And typically what they'll sue for is for negligence, for breach of fiduciary duties, and breach of CC&Rs. So those are the three main causes of action that we'll see that they will put in the complaint. Now, if you've got a young, aggressive lawyer, they'll throw in 12 more, and most of which are meaningless. But there is another one that causes a problem in that if you wait long enough and you don't clean up and take care of the water, you've got a mold issue. And the lawyer will throw in a mold issue, whether there really is one or not, but they will allege it, and it significantly increases the damage that they can claim, increases the cleanup costs, and mold is not covered by insurance. So the insurance company will defend, but if there are damages related to the mold, they're not responsible for those. And so that creates a problem if boards allow mold to grow in the walls. Okay, Laurie, what are the board's duties when there's a leak?
Yeah, so because of all the things that Adrian just talked about, instead of when the water's actually flowing, instead of standing there and looking and pointing fingers and saying, you owner, you're responsible, no, you association, you're responsible, the most important thing is to try to prevent as much resultant damage as possible. So you want to stop the water. That's the most important thing. And usually we recommend that the association have their vendors go in, figure out where the water's coming from, identify the source, stop the water. Because once you stop the water, that's going to help prevent additional damage from water that's flowing. So we got to stop the water. Identifying the source is also important because it could that's going to determine who's responsible to fix, in this case, that broken pipe. So the source of it could be is important to understand because it could go to who's ultimately responsible to fix it. But let's get the water stopped and figure out who's responsible later. The next thing is, like Adrian said, he talked about mold. Mold starts growing in a very short period of time. So we want to start drying everything out. Mitigating further damage, trying to prevent mold, that's the name of the game. That's the goal here. So we want to make sure we're drying everything. Now, we're not saying the board is going to be in there with fans. The association is going to bring in a remediation company and start getting the fans going and doing what it needs to do to get the unit dried.
Okay, what if like it was the owner that allowed her tub to overflow? So it's clearly not the association's fault, and they know right up front they didn't cause the damage. Do they still need to bring in a remediation company?
Yeah, I would say so, because like we talked about, some of the damage is in the common area. So the association is still responsible for that space between the two units is common area.
Right.
And again, the most important thing here is to mitigate damages. So to stand there and point the finger and try to figure out who's actually going to pay for all of this, that's going to be sorted out later. We want to prevent as much resultant damage as possible.
Every association should have a remediation company on speed dial, because as soon as the water damage, you've got water damage, you call them immediately. They start drying out everything, because the water in the walls, those walls are the association's common areas. and that's where the mold is going to start growing.
And
So
in
you're gonna
between the walls,
probably-
the
Right.
framing and all of that. Absolutely. And we want to document the damage. So the extent of the damage in case there's questions later as to how much resultant damage there was, what areas were damaged. When we talk about repair and replacement responsibilities, we might need to know which wall. Is it an interior non-bearing wall? That's going to determine who's responsible to fix it. Is it a bearing wall? So documenting the damage is also going to be important later on. And usually we ask, the remediation companies are pretty good about doing this. They're kind of the first responders, right? The remediation companies are the first responders in a water intrusion situation. So they're the ones that are seeing the damage firsthand, and they're in the best position to document it.
Yeah, and the documentation is important for the insurance company, so they can see, what was done, what the damage was. But also it's important because sometimes you'll get an owner that decides, oh, this is a great opportunity for me to completely remodel my unit.
Mhm.
And so based on a small area of damage, they want the association to pay for a complete remodel.
Mhm.
So it's important that you have the documentation to show, no, the entire unit was not damaged, only this small portion of the unit was damaged.
Mhm. Right. The other thing the boards need to do, and again, this can be through, probably most likely through management, is to notify and consult with the association's insurance professional. There may be insurance coverage here, so we want to make sure that we're talking to the insurance professional to determine whether the association's property damage insurance is going to be involved in this situation.
Yeah, and also you want to know, because we have notify/consult. It may be that the amount of damage was small and that your deductible is high, and maybe you don't want to make a claim. And that's why you're consulting with the broker to find out just exactly whether you should submit a claim or not. More often than not that you do, but this is why it's important to talk to them and to find out.
And a lot of times too, I know when I get a call from a manager and we're talking about a water intrusion, I ask questions that we're going to talk about, things like how much is the deductible? How much are the repairs? What's the scope of the association's insurance coverage? And a lot of times they don't know the answers to the questions. So even finding that information out ahead of time or right after water intrusion, that's important too. So again, consulting with the insurance professional to determine those items are going to all play a part in the overall picture.
Okay, and then the owner's duty is also to notify their insurance. A lot of times they will either not have insurance or they will refuse to notify their insurance because it was the woman up 2 floors up that caused the water damage. It wasn't them that caused the damage. So they don't want to notify their insurance because they don't want their rates to go up. So that's that's their duty. We can't make them notify their insurance, but we should at least tell them, owner, yes, you need to notify your insurance carrier. Okay, so now how do you tell the difference between real and personal property damage? Because their insurance, the owner's insurance, is going to cover their own personal property for sure. That's their responsibility. The association covers common areas, so it's covering the real property, not the personal property. So the question is, how can you tell the difference? There's an easy way to tell. If you turn the unit upside down, what falls out is personal property. So everything that's loose in the unit that falls out, that's personal property. Everything that's fixed in the unit, such as cabinets, counters, that island that you see, the hardwood floors, those are all real property improvements. So that's real property versus personal property. Okay, so on that neighbor to neighbor issue, is the association's insurance or the owner's insurance are both going to be involved. And you're looking at 2 different factors in order to make that determination. And that's the CC&Rs and the insurance policy. So what does the insurance policy cover, which Laurie's going to cover in a minute, and what do the CC&Rs cover? Now, I can tell you, typical language, this I pulled out of one of the sets of CC&Rs. It says the association shall obtain and maintain in effect the following types of insurance. And then it says blanket policy of insurance, and then look at the bolded part. that's going to cover all of the improvements in the project, naming all members as insured. And so this language means that the association's insurance, the owner can make a claim on the association's insurance. And you'll see an additional provision, blanket policy or policies of fire and casualty insurance with a full insurable replacement cost of common areas and the units. And it's surprising when you see this for the first time, you've got a loss, like such as the owner with the tub that overflowed and it hit all of the units down below, and you wouldn't think the association's policy is responsible for any of it. Yet here it is. It's in the language in the CC&Rs. And so what we do a lot when we amend or restate CC&Rs is that we change this language, because most boards don't want to have this language in here. And so more often than not, we're pulling this kind of language out. We're making the owner responsible for their units, the association responsible for the common area, but not for each of the owner's units. Okay, Laurie wants to talk to us about insurance policies. What
Yeah,
do they cover?
So when we're talking about the association's insurance policy, we're talking about the property damage policy. It's the same policy that's going to cover in the event of a fire, things like that. So there are three main scopes of coverage that the association's policy can have. What the scope of coverage needs to be could be dictated in the CC&Rs, like Adrian just talked about. The CC&Rs may have language that's going to dictate one of these scopes that we're going to talk about. The best practice is to have the CC&Rs be flexible, give the board the flexibility of determining the scope of coverage that the association's policy is going to cover. So there are three main levels, if you will, of coverage that the association's policy will have inside the unit. So we are talking about inside the separate interest, the units. The least amount of coverage that an association's policy will have. And we're talking here about condominiums for the most part. The condominium policy is the first party property damage policy on a condominium. So the least amount of coverage under the association's policy is what's called bare walls. Now, that's not a legal term. That's not an official term. It's just a term of art that's known in the industry. And under a bare walls policy, the association's policy is going to build back the unit to really what you're seeing here, the unfinished drywall. It's going to build back if any of the plumbing components inside those exterior walls are damaged, or electrical wiring, things like that. All of those items are going to be covered under the bare walls policy up to this unfinished surface of the drywall. Everything else, you're asking, well, how are the other things going to be paid for? What insurance is covering the other things to put back all the other things? That should be covered under the owner's policy.
Right. And before we go to the next one, the bare walls policy is the least expensive of all of these because it does the least amount of work.
Well, and also the advantage of a bare walls policy, which is why a lot of associations, gosh, it's been probably 15 years that the trend has been going towards a bare walls policy, is because the amount of items that can be damaged that the association's insurance has to pay for is a lot less under a bare walls policy than, so it can reduce the number of claims that are being made on the association's policy as well. So that's bare walls.
Okay, the next one.
So the next one is called, again, term of art, walls in policy. And under this policy, the association's insurance will cover those fixed items, that real property that Adrian talked about, the things that don't fall when you turn the unit upside down, the cabinets, the countertops, the built-in appliances, the floor coverings, all of those things are covered under the HOA's property damage policy. But they're covered to what we call builder's grade, what the quality of the items were when the builder installed them. So for instance, if the builder installed Formica countertops, that's what the association's insurance is going to pay for. They're going to pay for Formica, not granite or marble. So all those upgrades, any improvements or upgrades that the owners may have put in, that's not going to be covered under a walls-in policy under the association's insurance policy. Those upgrades should be covered by the owner's policy.
Okay, next one.
And then the all-in policy, this is the most amount of coverage that the association's policy is going to have inside the unit. And so it covers, again, all those fixed items, the real property, but it will cover the upgrades, any upgrades that were made by the owner. So that really nice cabinetry. This is a really nice kitchen, by the way. I would love to have this. But this really nice cabinetry, that marble countertop on the island, the hardwood flooring, that looks like a really expensive stove to me, oven. So
And
all
what
of
they
that
did with
would
the
be,
ceiling, if you look at that.
yeah, the ceiling work is amazing. It's beautiful. All of that is going to be covered in an all-in policy. We tend not to see the all-ins that frequently anymore, except I will say kind of in the higher end buildings, maybe the high rises. That's where we'll see the all-in policies. But we're not seeing as much of the all-in policies as we maybe once were. But if you have CC&Rs that have never been restated, it is possible that it dictates an all-in policy scope of coverage.
Yeah, which means that, and this is the most expensive, especially after the first claim. When the insurance company realizes just what they're insuring,
Yeah.
your premiums are going to go up.
Yeah, and I don't even know how they figure out, like, what, I think they just average what the upgrades are going to cost per unit or something. But how do they determine whether somebody has really expensive marble, versus, maybe a lesser expensive material? But
Okay.
again, most associations want to get away from the all-in policy, but some of those higher end, the high rises and things like that, you're going to see it. So when we're talking about whether the association's insurance is going to pay to repair resultant damage from water intrusion, it's important to understand what actual events, water intrusion events, are typically covered under the association's policies and what are typically not covered. And again, now we're the lawyers, we're not the insurance professionals. So ultimately, an association is going to want to consult. That's why we talked about consulting with the insurance professional to find out if there is coverage. But we can tell you from our experience that typically what is covered under the association's insurance is pipe bursts. And the language the insurance companies use is a sudden and accidental discharge of water from a contained piping system. So that's the pipe burst. Sewer backups are typically covered. Sometimes they require an additional endorsement or rider. So again, you're going to need to check with your insurance professional, but those are covered. And then, like I said, the association's property damage insurance policy is the same policy that will cover and repair damage due to fire as well. So that's typically covered. Typically not covered. So this is important to understand that there are certain water intrusion events that aren't covered under the property damage insurance policy. So we won't be making a claim in those situations. Again, defer to the insurance professional, but generally pinhole pipe leaks. It's not that sudden and accidental discharge of water from a contained piping system. That's
It's
so pinhole
accidental. It's accidental, but not sudden.
but not sudden, right? So
Right.
it's sudden and accidental. Roof leaks, and a lot of people are surprised to find out that roof leaks generally are not covered under the property damage insurance policy. The reason is because the insurance companies see it as a maintenance situation, that if proper maintenance, the roof shouldn't leak, but that's how they see it. There can be situations where roof leaks are covered though. If there is wind and the wind blows off a portion of the roof and then it rains and water gets in, that can be covered. But generally your garden variety roof leaks typically aren't going to be covered. Window leaks also, they see that as a maintenance responsibility like the roof. So usually water coming in from a window is not going to be covered by insurance. And then earthquakes are not covered under the property damage insurance policy. That's a different policy. And we don't have a bullet here, but I'll throw in floods. And a lot of times we say, oh, there was a flood, right? From a pipe burst, it flooded. But floods, when we're talking about like atmospheric rain events that leads to accumulation of water from that, that's a flood, and that's a separate policy, a flood insurance policy.
Okay, the common lines, the association, oops, go back to common.
Ah,
There we go. All right, common lines. So unless otherwise provided in the CCNRs, the owner of each separate interest is responsible for repairing, replacing, maintaining that separate interest. Okay, well, a line that's going up, as you can see here, from unit to unit up through the building, that's a common area line. That's the association's responsibility. And the association really can't get around this. This is just their responsibility. They need to take care of it. So both by under the statute in the Davis-Stirling Act and in the CCNRs, the association is responsible for dealing with these kinds of lines. Now, then you have what's called exclusive use lines, and we're servicing the unit only. So as you can see here in this illustration, these water lines are going into the unit and they're not going into other units. So this would be an exclusively use line. Per statute, unless the CCNRs provide otherwise, owner is responsible for maintaining them. But the association is going to be responsible for repairing and replacing them. So this, again, shows up when we're amending and restating CCNRs. More often than not, boards will want the owner to be responsible for their own lines, just like they would be if they owned a house. So they'd be responsible for the exclusive use lines. But what you see in original sets of CCNRs is the owners are not responsible. The association is. So that's why it's important if you're amending or restating your CCNRs, that's the appropriate time to be looking at who do you want to make responsible for these exclusive use lines. Okay, and then you see, on older buildings, the developer would have used maybe galvanized pipe. And this is, you can see in the lower illustration there, that's what happens to galvanized pipe over time. It corrodes, mineral deposits accumulate, the walls start thinning out from the inside out, and they will fail. And when they start failing, it's going to be building wide, and you're going to have to repipe the entire building. So you can't just patch these. At some point, you have to replace them, and you want to be reserving for it. And too often, associations will fail to reserve for plumbing inside the walls and having to do a complete repipe. When you repipe, typically, you're going to be using copper. Copper has been the standard for decades now. But the problem with copper is it's not flexible, it's expensive, and you have to use a torch in order to solder the joints, which can lead to potential fires. And occasionally a plumber will start a fire with their torch. There is a new product out called PEX, and it's less expensive than copper. It's easier to install, it's flexible, it's plastic. So we're starting to see more PEX being used in repiping situations.
And you want to make sure it's PEX, not polybutylene.
Right. Okay. And then you've got cast iron for the drain lines. Cast iron is pretty standard, but cast iron also can corrode over time. It's quite heavy because it's iron, but this is what it looks like as it starts to corrode, even though it's a drain line. So this buildup is actually mineral buildup.
So you're talking about drain lines, like sewer drain lines. So Adrian, are
Yes.
you sure this is what rust that we're looking at here? That
Yeah,
brown
this is
stuff?
Yeah,
It's
that's
rust.
mineral buildup.
Okay, all right, just making
And
sure.
the problem as it builds up, it gets harder and harder for snakes to go down, snake line. And we're not talking about the animal snake.
Are they
talking about
animals or
what-
reptiles?
Yeah, that's a reptile. Putting a line down to clear clogs, because as this builds up, it starts constricting and getting smaller and smaller, which also leads to more backups because it's a smaller line now.
So what are they
and so
using
you-
now instead of cast iron?
Well, they're still using cast iron, but now we're starting to see more fire safe products. So again, these are a form of plastic that's used, and they don't have that mineral buildup. They are easier to clean, and so they don't crack and corrode like the cast iron does. So just for owners, for homeowners and board members and managers to be aware, there are other products that are less expensive and easier to install. So we're starting to see more of these being used. Okay, windows. Talk to us about them, Laurie.
So yeah, the windows are also another source of where water can intrude in from the exterior inside. So the responsibility for maintenance, repair, and replacement of the windows you're going to have to look at the CC&Rs and the condominium plan to determine, is it part of the unit? Is it part of the common area? A lot of times in a condominium, the windows are going to be the association's responsibility to maintain, repair, and replace. But the interesting situation is when you get the owners who replace their own windows, and let's say it's not done correctly and it's not put in correctly, or it's not caulked correctly, and that leads to water intrusion. You want to make sure your CC&Rs are saying that even if the association is responsible for windows, maybe any replacement windows that were installed by owners or prior owners, or the owner's responsibility. But you do need to look and make sure you understand who's responsible for the maintenance, repair, and replacement. If it's the association, we want to make sure we're reserving for the replacement of those windows.
Typically what I see is that the owner is responsible for maintenance. So cleaning the windows, unless in a high rise, then the association is going to be responsible for the exterior. But for interior cleaning and those kinds of things. And the reason why associations are generally responsible, almost always, for replacing windows, repairing, replacing them, they're part of the wall. So it's not part of the interior improvements to the unit. It's part of the wall, so it makes it common area. And so that's why the association is responsible for repairing, replacing. And too often they don't reserve for them. And they should be, because you start getting to the 30-year mark, 30, 40 years, you're going to start having to replace windows. So it's something it's important for boards to realize and make sure that these are in their reserve study, and that they've got the money available down the road when they need to replace them.
Yeah, so we do have some recommendations we have for associations in regards to addressing water intrusion situations, even the insurance, is you want to make sure you have your CC&Rs clearly define the maintenance, not only maintenance, but repair and replacement. Because again, in a water intrusion incident, who's responsible to repair and replace the items that were damaged from the water is going to depend on what the CC&Rs say. And if the CC&Rs aren't specific, it's going to default to the civil code. We recommend a maintenance responsibility chart, or a maintenance matrix, you might have heard it, that clearly sets forth for each element who's responsible to maintain, repair, replace. We even put paint in our maintenance responsibility charts, because who has to paint the element is also an important, sometimes it's the exterior.
Yeah, let me show a chart and then we'll go back to the recommendations.
Yeah, so here you can see we've got the items listed, and we have either a full responsibility, that means O is owner, A is association. But we also have it broken down by, again, maintain, paint, repair, and replace. And it can even be broken down under paint, as far as the association might paint the exterior and the owner might be responsible for painting the interior. But here we have, we have some of these water intrusion items or resultant damage. The ceiling surfaces here, see, we say the owner is responsible here for the ceiling surfaces. So the full responsibility, that means they're going to have to replace the drywall if the drywall is damaged due to a water intrusion incident. We have the same responsibility generally for drywall. We say the owner is responsible for the drywall, even on those common area bearing or perimeter walls, that the owner is responsible to maintain, repair, and replace. So that limits the association's responsibility.
Okay, let's go back to the recommendations.
Yep. You definitely want to look at the insurance provisions. If your CC&Rs mandate a all-in scope of coverage, remember that was pretty kitchen. And you, as an association, don't want to be responsible for having to have the association's insurance pay to replace everybody's marble countertops. then you want to look at the insurance provisions. And again, best practice, in my opinion, certainly is to have the CCNRs give the board flexibility to determine the scope of insurance coverage on the property damage policy. There could be situations where a bare walls policy is appropriate. There could be situations where more scope of coverage is appropriate, but that should be up to the boards to determine in consultation with their insurance professional. So we like to see flexibility in the CCNRs.
Yeah, and the reason why we either the most often used is the bare walls or the not the all in, but the what's the one?
All the walls in.
Yeah, so that the walls in, right? Is that you don't know what improvements owners have made to their units, and that's part of their real property improvements, and they should be responsible for those. One of my associations, the owner had a gold leafed wallpaper, and he had flown in somebody from Italy. He had then had the ceilings hand painted by this artist from Italy. So do you want the association to be responsible for those kinds of improvements? Generally, no. So that's why you don't want the complete will replace everything and fly in the guy from Italy and have him redo or repaint it. So it is important that you know what you are insuring. So you need to look at your CCNRs and decide, do you want to keep it that way, or do you need to amend them and change what you're actually insuring?
Yeah. And then the other recommendation that we have is to adopt some kind of protocol procedures for handling water intrusion incidents. So if you want to go to the next slide, we can talk a little bit more about that. Sorry, the next slide. So we call it a water intrusion and mold protocol, and having that some kind of protocol in place is going to be helpful for when water's actually flowing. Ideally, the protocol will set forth all the maintenance and repair and replacement obligations of the association and the owner. I like putting in an inspection obligation to require owners to inspect their units and notify the association if there's any obvious water intrusion. Because again, if the association doesn't know about it right away and can't get in to do anything about it, that's going to lead to mold occurring. So we want to have the owners take responsibility to inspect their units and promptly notify the association if they notice water damage or water coming in. It's going to talk about reporting protocols, who's calling who's bringing in who, mitigating damage. It'll have information about how to prevent mold, what to do to take precautions for mold, and if mold is visible, what to do in those circumstances. I do like having the insurance laid out in a water intrusion policy. It'll talk about reporting. It'll talk about the scope. It'll set forth what scope of coverage. Is it bare walls that the association has, or all in, or walls in, and set forth the amount of the deductible, because the amount of the deductible does play a part in whether or not a claim is being made on the association's policy.
Yeah, and to add to this, the importance of having a written protocol and also to amending your CCNRs is that future boards, you want to make sure there's consistency in how they're handling these issues. And they don't necessarily know unless they've got something in writing that tells them what they're supposed to be doing.
Yeah.
And also if you've got turnover in management, these kinds of having things in writing, and it's also helpful to have for new boards coming in to have a training session with the new board, and to deal with, to walk them through what their responsibilities are as directors. And there's a lot more involved, than just these issues that we're covering, but this is really important, dealing with water damage and insurance. Okay.
Yeah, it's not in here, but I think another important point when we're talking about water intrusion is some of it can be prevented. Certainly roof leaks, making sure that you're doing whatever preventative maintenance, clearing rain gutters, making sure landscape drains are clear. All that could actually go to preventing a water intrusion event. So you want to make sure that you're consulting with your maintenance contractors, that you understand what preventative maintenance can be done, what time of year should it be done, because you might be able to actually prevent a water intrusion incident as well.
Okay, and the reason why is because you don't want to be hitting your insurance if you can avoid it. And Saturday, State Farm announced that they were non-renewing 72,000 insurance policies in California. So in their announcement that the insurance crisis has been aggravated here even further. We know how difficult it's been already for associations to purchase insurance, and how premiums have been skyrocketing as a result. So any claims that you can avoid making on your insurance is really important. And another one, a case I reported on in the last newsletter, was Bear Valley Springs versus Pena, where the owner was unhappy. Her shingles on her unit were getting bare, and she made a demand on the association to replace them. Well, they didn't think it was ready yet to be replaced. So what'd she do? She went around the board, went straight to the insurance carrier, and made basically told them that the association was negligent in their maintenance responsibilities. So what's the insurance company do? Cancels it. It didn't cancel it, non-renewed. And so the association had to go out, and it resulted in a 400% increase in their premiums. They turned around and sued Pena. The lower court decided that she was responsible for the increase. She appealed, and the Court of Appeal agreed with the lower court that her actions were not protected, and affirmed the lower court's ruling. So this is one of these rare cases that we see where an owner can actually be held responsible for the resultant increase in insurance because of their actions. But this also shows that if you make a claim on your policy, you could find yourself getting non-renewed, especially if it's a big claim or a lot of little ones. Because even small claims, if there are a lot of them, the insurance company is looking at this and going, okay, this is not going to stop. They're obviously not maintaining, they're not doing what they need to do. We're going to see a lot more claims coming at us, and they don't renew. And then you go back out in the marketplace and you're looking at a 400% increase. And we have clients that have had significantly more percentage increases than that. So this insurance crisis they're talking about really is a crisis, and we don't know when and how it's going to get resolved.
Yeah, and I'm starting to see now too, owners are reluctant, like we touched about on this earlier. Owners are reluctant to make claims on their own policies, because now even an owner making a claim could turn into their rates going up. And if they think the association is somehow at fault and should be responsible for all the resultant damage that happened because of a water intrusion event, we're starting to get pushback from owners about making claims on their own policies.
Okay. For more information on what an association's responsibilities are and an owner's responsibilities, you can find this on our website. Just go to the index, go down to maintenance, click on maintenance. It'll take you to the maintenance menu, where you've got a lot of different options here or articles to look at, information dealing with plumbing issues, who's responsible, reserve issues, sewer lines, even pests in buildings that need to be removed. So dealing with pests issues, and so it's an easy way to find additional information. So at this point, we're going to go to questions, and we're going to take an earlier question that came in and answer it while Miranda is looking at the questions coming in. So the question that came in was, with the recent Pineapple Express, a unit suffered water damage from the deck. Is this an act of God? And can the board claim non-responsibility and refer the owner to their own insurance company? Came in from Denise. So Laurie, what do you think?
It depends.
You must be a lawyer.
Yeah, I mean, there's a lot to unpack here. First of all, if the water intrusion event is even one that's covered under the property damage policy or another policy, we would need to know the answer to that question. But I think, as we've talked about, is if the items that were damaged is covered by the association's insurance. There may be an obligation on the association's part to make a claim on their
Yeah,
policy.
Yeah, and I would say that this goes to our last webinar, and that's who's responsible for maintenance of the deck. So if it's just regular rain coming in from a storm, and the association is responsible for the maintenance, and you've got now a leak because they didn't maintain the deck, and it's going into the unit and the unit down below, you've got common areas being affected. The association again is going to be on the line. But if it was damage caused by the owner that allowed the leak to occur, the association will still be responsible for the repairs, but they can go against the owner for having caused the damage. Okay, so let's go to Miranda, and what questions do you have for us?
We have a lot of questions.
I
Everyone
bet.
submitted a lot of questions. So just as a reminder, whatever we don't get through today, please look to our next newsletter. Okay, so do you recommend that the HOA creates a water leak policy, and what should or should not go into that policy?
I think we already covered that, but yes, there should be, I like to call it, we call it kind of a water intrusion protocol or something like that. And it should cover all the things that we've talked about, making sure we understand repair and replacement obligations, insurance coverage,
Right.
protocol, what's going to happen when, who's calling who to bring in remediation companies, things like that. So, you know,
And typically you'd have the manager handling this, and especially if it's an after hours. But if they can't reach the manager, the board member should also have that protocol, and they should have that remediation company on speed dial so that they can immediately get somebody out there to stop the water and start cleaning it up to minimize the damage. And then you can figure out later who's responsible. If indeed the owner with the tub overflow, you can back charge them for the damage.
Yeah, and also we we talked about, didn't really touch on this, but the protocol should also include how the repairs, that the payment for repairs that aren't covered because of the deductible, the association's deductible.
Right.
Who's responsible for that? So we call it a deductible allocation. We address who's responsible to pay for the repairs that because of the deductible. So that should be in the policy as well.
Miranda, next question.
What if delay in repairs is due to a slow contractor response?
Oh, well, that's between the association and the contractor. And if there's additional damage caused because and here's typically what happens. They'll come in and they will put a temporary patch on the roof, but they won't do it very well, and the roof leaks. Then the association, do we have a breach of contract situation? So this is something for the association to look at with legal counsel and determine what is the best course of action.
Yeah, but like Adrian said, it's the additional damage. Remember, the water intrusion already caused damage. So it's what additional damage has occurred because of any alleged delays.
Downstairs owners are still held responsible in most cases for upstairs leaks. Their deductible, their insurance loss, their premium increases. What can be done about this?
Don't live downstairs.
But even living on top,
yeah, you get the roof leaks.
You got the roof leaks. And if you're at the bottom level, you get the sewer backups, the drain line.
No, I mean, all kidding aside, like I just said, we are seeing this. This is becoming a problem. Owners don't want to put claims on their policies for something they don't think is their quote fault. But just keep in mind that just because the water intrusion originated from a unit upstairs doesn't mean the owner upstairs is at fault, quote unquote. And also, and the insurance companies, when we're talking about property damage insurance, they're not really concerned about who's at fault. They're looking at, are the items that were damaged that need to be repaired or replaced, are they covered under somebody's insurance policy?
Right. But if you've got a lower unit and the upper unit caused the problem, such as the woman with the tub overflow, and they don't have insurance, or the owner down below doesn't have enough insurance, they still have recourse to the courts against that owner.
Yeah, I mean, there's a difference between negligence, like turning on the bathtub and forgetting about it, and a pipe that bursts.
Right.
Because you have to prove negligence. Now you're talking about a liability claim, and you actually have to prove negligence.
Right. Okay, Miranda, next question.
Are HOAs obligated to fix water hammer?
Water hammers?
Oh, yeah, that's a noise. That's a hammering noise in the pipes. And that's the association's lines. And typically, yes, it would be the association's responsibility. And there are ways to fix that. So they just need to talk to a plumber.
All right, tree roots damaged clean out pipes. How do we determine if board or owner pays?
So we'd have to look at their documents and we need to see where the roots invaded. And if it's the association's trees or not, if it's the owner's trees. So you have owners even in townhouses or condominiums on the ground floor. Normally it's going to be the main lines going out. It's the association all the way out to the main line in the street. So
And
we
usually
just
it's the association's trees whose roots are
right.
invading the system. But again, this is where kind of, putting the onus on the owners to inspect if they're starting to have plumbing issues, maybe the toilets getting clogged a few times. We need to, perhaps some investigation before an actual backup might reveal the source.
Right, what's
and,
causing it.
Yeah, and
So
what could be done.
Yeah, and the association they shouldn't just be running a snake down the line, clearing it out until the
Camera.
next time it clogs. They should run a camera down the line, find out what's
Yep.
going on.
And
And if
making
you've
sure
got
it's clear.
invading units, right, if you've got invading roots, they may need to replace that line so the roots can't get into it.
Right. And yeah, and definitely looking to make sure it's clear. Not only in sewer lines, but landscape drains. I had a situation where there was a backup on a patio due to the association not clearing the landscape drains adequately after they had been notified of backups on the patio. So.
Yep, and once the association put on notice of a problem, then the next time it happens, they may be negligent because they didn't investigate and take care of the issue in the first place.
Exactly.
Okay, Miranda, what's the next question?
You're talking a lot about mold. How big of a deal is it really?
Well, if the association doesn't address it and they let it go on, especially with pinhole leaks, if they're slow, you've got water going into the walls that might not show up in the unit for a while. And the longer it's there, the more mold will grow. As long as it's contained in the walls and hasn't yet invaded the unit, there's not a health issue. But once where this shows up, you've got a wall, the plumber says, oh, we got a problem, let's find the leak. They open up the wall and they haven't contained the area and it's filled with mold. Mold is now into the entire unit. So mold can become a significant issue.
Mm-hmm.
All right. What does HOA do when owner's insurance company denies all internal repairs and covering personal property?
Well, the association gets to make their own determinations as to who's at fault. And so this is where legal counsel looks at and it looks at the situation and the governing documents, and they may make a determination different from the insurance company. So what's the insurance company's primary goal? Does anybody know?
Say no.
To say no, not to pay out any monies. They're going to initially say no a lot of times when in fact they may be responsible.
Yeah.
So the association can still make the repairs, and if they make a determination, a legitimate determination that the owner is responsible, and if the governing documents allow them to impose a reimbursement special assessment, they may do that.
Yeah, but I mean, the question was personal property. I think it's a very rare circumstance. I mean, there's no circumstance where the HOA's insurance company is going, insurance policy, at least the property damage policy, is going to cover personal property of the owner.
They may as part of the settlement. is possible, but again, you just can't make a hard statement that's going to apply to all situations.
Right.
So it depends on the association's governing documents, what kind of insurance they have, what the owner's insurance covers. So we can't give you a clear answer on that. Go ahead, Miranda.
Can the maintenance matrix be provided to the homeowners?
Yes, it should be part of the CCNRs in order to actually be govern the maintenance, repair, replacement obligations. It has to be part of the CCNRs. So it would be made available.
Yeah, well, it can be part of the rules, but as long as it reflects the CCNRs. But if we like it to be a part of the CCNRs because that's very clear. It goes from owner to owner. It stays with the property, and it spells out. And they're deemed to be on notice of their responsibilities if it's a recorded document.
Yeah.
And even if
next.
it's rules, it still should have been sent out to the community.
Absolutely.
Right.
And keep in mind, as rules, it's just an interpretation of what the maintenance, repair, replacement obligations are under the CCNRs, because the rules cannot set forth maintenance, repair, replacement obligations. It has to be in the declaration. It can't override. And if you're wanting to override what the civil code says, who's responsible to maintain, repair, and replace, that can only be done in the CCNRs.
Right. Okay,
Right.
next.
What if your association does not have CCNRs?
Oh.
Well,
it's
it
not
might be
Davis-Stirling?
well, it
Yeah,
could be a mutual. I'm wondering if it's a
Right,
mutual. A
could
lot of
be.
mutuals don't have, a lot of stock cooperatives don't have CCNRs. So,
Right.
um,
Then you look at what governing documents they do have.
right.
What happens if one owner has no or insufficient insurance?
Yeah, well, that owner may find themselves in a jam. In that they may be personally responsible on the hook for whatever damage, and if it's significant, they're going to be in trouble. They maybe find themselves sued in court if they're not dealing with the problem.
And if it's, if the association has a bare wall scope of coverage, you saw what the association is going to build back to. So they're going to be living in a shell of a unit, in a unit with drywall, but nothing else.
Right.
Who will be responsible for paying for the repairs to the common area if the damages were caused by the owner?
It depends what the CCNR say, but, and.
Yeah, but if it's common area, the association is going to be repairing the common area.
Right.
And then if the governing documents allow, and if insurance has already been a claim made and the insurance paid for it, then that's it. You're probably not going to be, there's going to be no subrogation back against the owner. But if insurance was not involved, the association paid for the repair, it wasn't that big, so you didn't make a claim, you may be going against the owner for reimbursement special assessment.
Yeah.
Right.
Should we notify or file a claim with insurance agent?
You should consult with the insurance professional. Given the situation, they're going to be able to give you guidance as to the pros and cons of making a claim and ultimately making that determination whether a claim is going to be filed. But at a minimum, you should consult with the insurance professional and give them all the facts and circumstances.
It depends on too how big the damage the claim is going to be. So a smaller claim, and if your deductible, if it's within your deductible, you don't want to be making a claim against your insurance, especially if the broker says, "Look, you make another claim, we're going to non-renew."
Exactly.
And so that's why it's important to consult with them.
Right.
All right. What is the responsibility for homeowners having to move out / hotel bills?
Well, that does come up. It depends on your documents and your insurance, but more often than not, the association is not responsible. But it may be that they will make an exception depending on the circumstances in order to get the owner out of there without a fight, so they can quickly make repairs and then get them back in. So it's going to be depending on the particular situation, but more often than not, they're not responsible.
The association is not responsible more often than not. I agree with that.
Okay, what about in the instance when the leak is coming from a wall that's common area but affects the owner's interior area, but the association refuses to fix it?
I don't know what they're talking
Sure.
about fixing. If it's a common area pipe, the association needs to fix the pipe, no question.
Right.
If
And the
that's
wall.
their responsibility. If we're talking about the resultant damage, then we're likely looking at insurance coverage and which policy is going to cover the items that were damaged.
Yeah, and it's not strict liability where the association is
Right.
automatically responsible for all damage. There has to be a negligence element. So if the association knew about these leaks, they've had a lot of these leaks, there was a leak in that wall previously, whatever the circumstances are, maybe association is going to be on the hook for all the damage because they didn't do their job. They didn't take the necessary steps to prevent it from happening again.
Photos should be taken as soon as the leak is found in the area of the leak and walls, correct?
If possible, but don't stop looking for turning off the water to make sure you get in the photo.
Right.
Turn
Right.
keep the priority straight.
Right, stop
Get-
the water.
Stop
But
the
you
water.
got- Pull out the camera, pull out your phone, take a
Yeah.
picture. And if it's before the remediation company even gets there, yes, you should be taking pictures. And then the remediation company takes over from there.
How do we demand that owners keep insurance for their unit in addition to the HOA insurance?
A lot of times the CCNRs do require the owners to
Right.
carry insurance. So, so a lot of times the language is in the CCNRs, especially if it's been updated.
Now, and then typically what we do is we put in a line that says the association may, but is not obligated to make sure that everybody has insurance. The reason being is that it's administratively, it's going to be a real burden trying to make sure everybody has a policy and that they get you a copy of it or proof of insurance. And then the next thing that happens, as soon as they provide you proof, they cancel it. And then what happens is that there's a loss and the owner that caused the loss doesn't have insurance. And then the association gets sued because they didn't enforce the CCNRs. So it can be a real problem. You have to make sure you've got the right language in there. You can require owners have the insurance, but you don't want to make sure that you don't want to make the association responsible for ensuring that they have it.
Ensuring, not insuring.
Yeah, ensuring with an E.
Yeah, I agree with that. I don't, it would be impossible for the association to keep track of everybody's insurance because they have all different expiration dates and things like that. So requiring the owners to have insurance, but not making the association obligated to require proof or anything like that,
Right.
unless they're, sometimes boards are notified that a certain owner doesn't have insurance or might not have insurance. In that case, we're able to ask for proof.
Yeah, and then you've always got owners who says none of your business. I'm not going to give you any proof of anything, and then you're in a big fight with the owner.
I've had owners say, I can self-insure. I don't need insurance because I have enough money that I can cover whatever damage. And that's an interesting argument too. Great,
Right.
show me your bank account then.
Okay, Miranda?
All right. What if you don't know what builder grade units originally had? We have units built in 1964.
Right, that does come up from time to time. The older the building, the more difficult it is to determine what was the original builder grade. And if you have a unit that does have the original, this would be a good time to take pictures of that unit and store them so that you know what the original builder grade was.
But ultimately too, it's the insurance company. They have to write the policy for that. And they have to make sure they have, more importantly, that they have enough coverage, money to cover what it is. So really the burden is on the insurance company to determine what the builder's grade would have been for that era, that age, and have appropriate
Right, and they should
insurance.
be able to.
Yeah,
Right.
appropriate replacement costs based on that.
Okay, we're at 11 minutes after. Let's take a couple more and then we'll stop. And then because there are people that need to be dropping off, but reminder to everybody that we are recording this, so you can review it at your leisure if you do need to drop off. Okay,
And thanks for
Miranda?
joining us today.
Right.
On our YouTube channel, on our website. All right. Doesn't a change in our CCNRs require 70% owner approval?
So it depends on what the CCNR say. There is an amendment, there should be an amendment provision in the CCNRs, and it will set forth the percentage of approval. If there is no, I don't think I've ever seen a set of CCNRs yet that didn't have an amendment provision, an actual CID for common interest development. But if it doesn't, then the Davis-Stirling Act says it's a majority of the members that have to approve an amendment to the CCNRs. But it's in the CCNR somewhere.
Yeah, typically you'll, especially in older ones, are 75%, which is darn near impossible. Some I've seen at 60%.
Or 67%. It's either 75% or 67% are the most common supermajority requirements.
Right. And if you can't reach it, as long as you hit 50% approval, then we can go into court. And 9 times out of 10, the court will approve the restated CCNRs. Okay, Miranda.
Right. What if access to the unit that is causing the leak and the owner is not home? Can the HOA or affected owner break into the affected unit, or would they call the fire department?
You mean just, I'm assuming to stop the water? Is that what they're talking about?
Yeah,
I don't know.
Right.
Yourself.
If it's a drip leak, you don't go breaking into the unit. If there's water gushing out of the unit and impacting the units down below, it may be that you would call the fire department, and they can break into the unit, and they can break down the door. If you're a high rise and you've got keys, it may be faster for you to go into the unit because you've already got keys to the unit and stop the water. Because water, it can cause a lot of damage very quickly, and as it goes down from unit to unit.
Most CCNRs do have a provision called right of entry that does give the association and its agents the right to enter units for those purposes. And especially in an emergency situation, usually no prior notice is required. And the association could usually would, if in that situation, the association would have a locksmith to assist with entry as well. Okay.
If our vendor repairs the damage, charges back the owner, then later down the line, it needs repair again for whatever reason, who's responsible for that? HOA because they hired them, or homeowner because it lies in their responsibility?
Yeah, I mean, I think we need to know more about the specific circumstances to answer that question. But if generally speaking, if the association hired the contractor and the contractor didn't fix it properly, it's going to be between the association and the contractor.
Right. Okay, let's get one more in.
One more, yeah.
All right, I'm trying to pick a good one. Okay, if source of water intrusion and or mold in a crawl space or foundation is rain water on a patio and not a pipe leak, who is responsible?
Okay, so the crawl space under the building, if these are townhouses, it's going to be, and if it's the owner, if it's planned development, the owner is responsible because they own the land underneath. If it's a condominium association, the association owns the land underneath. So if you've got water coming up from underneath and that's causing the problem, the owner may be, or the association may be responsible for making sure that that water is drained off and that it's not causing damage.
So water intrusion,
yeah, we just need to know the circumstances and what kind of structure it is that we're talking about.
But water intrusion can come in from outside the building. You know, it can come in through cracks in the stucco or, you know, lots of other circumstances. So again, you're going to have to look at the maintenance, repair, replacement obligations to determine and figure out where the water is actually coming from to determine who has to take the steps to prevent the water intrusion.
Okay. All right. So thank you, everyone. I'm going to turn it over to Miranda for final statements here.
Thank you again to all of our attendees and speakers. As always, please do not hesitate to reach out to us with your questions. We'll see you guys next time.
All right. Thanks, everybody. Thanks for joining us.
Thank you.